Hi guys, I hope you all are doing great. So let's move to the second part of our marathon, which is your Limited Liability Partnership Act video. Okay, marathon of Limited Liability Partnership Act. So in the Limited Liability Partnership Act, we have seen this is a new form of legal business entity with limited liability. So here partnership is there, but the liability is limited. Here the partners won't have to bring from their home the money to pay for the business debts. Okay, this is an alternative corporate business cycle. This is an alternative to corporate business. Instead of companies, you can form the LLPs. Okay, now next is allows the partners the flexibility of organizing their internal structure. So you can organize your internal structure as you want. In the companies, what is there, you have a specific number of shares, so that is to be distributed, share value is distributed. Here you can have the benefit of partnership also, right? You can maintain the ratios, profit sharing ratio, and then you can decide what amount of capital is to be brought. LLP itself will be liable for the full extent of its assets. Liability of partners will be limited. So LLP itself will be liable for the full extent of its asset. It is going to act as a separate entity. Okay, and the partner's liability is limited over here. I hope the first point is clear. Great. Let's go ahead in the second point, that is body corporate. It means a company defined in clause 20 of subsection clause 20 of section 2 of the Companies Act 2013, and your body corporate will include LLP registered under the LLP Act 2008. LLP incorporated outside India will also be covered under the body corporate, and a company incorporated outside India will also be covered under body corporate. So body corporate will have four kind of body corporates can be there. So one is your LLP, one is your normal company, then is your LLP outside India, right? I'll use OS as a shortcut, and company outside India. Okay. Now, but body corporate does not include a corporation sole, a cooperative society registered under the any law that is under the that is time being in force, and any other body corporate not being a company defined in clause 20 of section 2 of the Companies Act 2013, or a LLP defined in this act. So any body corporate which is excluded from considering as a body corporate over here, that will be excluded, which the central government by notification, the official gazette specified this behalf. If central government is specifying that this will be not included in body corporate, so you have to exclude that body corporate. Okay, let's go ahead with business. What business includes? So business, as we all know, every trade, profession, service, occupation, except any activity which the central government has excluded, all this will be included in your business. You do trade, you do profession, you are giving your professional services, you are giving some normal services, cleaning services, you are doing some occupation, that is all included in your business definition. Okay, so this is a marathon, so it's going to be a little fast for you people. I hope we are good at the speed. Designated partner. So designated partner is compulsory in LLP, and section 7 talks about designated partner. Then we have foreign LLP. Foreign LLP means LLP formed, incorporated or registered outside India. So it can be formed outside India, it can be incorporated outside India, or it is registered outside India. That type of LLP will be called as foreign LLP, which establishes a place of business within India. Foreign LLP will be considered in our in our regime and in our LLP Act when it has a place of business within India. If it does not have a place of business in India, we are not aware about it. Like, we don't have to do anything about it. Okay. Next is your LLP, Limited Liability Partnership. What does it mean? It means a partnership formed and registered under the LLP Act 2018. Then for this registration of LLP, we will be needing an agreement, any written agreement, okay, between the partners of the LLP or between the LLP and its partners is called as LLP agreement, which determines what mutual rights and duties of partners. So it is going to determine the mutual rights and duties of partners and their rights and duties in relation to LLP. What rights and duties are there of the partners towards LLP, and what benefits LLP is going to give them. All this is written in your LLP agreement. Okay, great. Now, who is a partner to LLP means any person who becomes a partner in the LLP will be a LLP partner in accordance with the LLP agreement. So their name should be mentioned in the LLP agreement. They should be a person who is competent enough, right? Great. small limited liability partnership, the contribution of which does not exceed 25 lakh or which or such higher amount and not exceeding 5 crore as may be described, and small LLP means which meets other requirements, and this type of things are not much applicable to you people, so we can just skip this part also. Okay, so this is not much relevant for us. Let's go to the next one so that we'll be going further with it. Okay, 1 second. Now, non-applicability of Indian Partnership Act. To your LLP, the Indian Partnership Act will not be applicable. Okay, shall not apply to LLP. Save as otherwise provided, the provisions of Indian Partnership Act shall not apply to LLP. LLP will have their own act, own working. They won't be following the Indian Partnership Act. Okay, now who are the partners of LLP? Who can be the partners? Let's see. Any body corporate can become a partner, right? Any individual, or however an individual shall not be capable of becoming partner LLP if. So we have to recall competence of partners. Any individual can become a partner, but that person should not be of unsound mind. He should not be undischarged insolvent, or he has not applied for to be adjudicated as insolvent. If the person is of unsound mind, he can't become the LLP partner. And then if he is an undischarged insolvent, again he can't become the LLP partner. Then if he has applied for adjudication as an insolvent and his application is pending, that time also you can't say that this person can become a partner in LLP. Okay, I hope the partners is clear. Any individual or body corporate, and in individual 3 exceptions are there. The person should not be of unsound mind, should not be an undischarged insolvent, or should not have applied for adjudication as an insolvent where his application is pending. Okay, this they can ask you as a direct question from LLP chapter, so it's better that you revise all the concepts of LLP today very nicely, because this is a very scoring chapter for you, very easy chapter for you. Okay, so every LLP shall have at least 2 partners. So our partnership will only form when we have 2 partners. So same case is there in LLP, minimum 2 partners are required. If at the time the number of partners of LLP is reduced below 2 and the LLP carries on business for more than 6 months while the number is reduced, the person who is only partner of the LLP during the time shall be liable personally for the obligations. If only one person is running the LLP, 2 partners were there, one of them retires, and for the next 6 months also the partnership is continuing, they are working. So in that case, your person, the partner who's only working, the single partner who's working, will be liable for all the expenses, all the obligations himself. He will be liable personally for all the obligations of LLP. Okay, because he is only running the business, he is only taking the profit, so he will be liable personally. Personally, this is important, you should remember. Okay. Now, then we have your designated partners. So we see in section number 2, they have said at least 2 designated partners are there who are individuals and at least one of them is resident of India. So designated partner, body corporate can't be the designated partner, only individual. Okay, only individual can be your designated partner, and this designated partner should be a resident. Only at least one of them should be a resident of India. For resident, here you see what conditions are there: who has stayed in India for a period of not less than 120 days during the financial year. So this person should stay in India for not less than 120 days in a year. In case of LLP, where all the partners or body corporate, all the partners are body corporate, or in which one or more partners are individuals and body corporates, at least 2 individuals who are partners of such LLP, nominees of such body corporate, shall act as designated partners. So if all of your partners are body corporates or a mix of individual and body corporate, so you don't have all of them resident, so what you can do, nominee of such body corporate, the person who is going to be the nominee of body corporate will can also be a designated partner. Suppose if ABC LLP is there, okay, and it contains around 3 individuals. This one is a non-resident, he lives outside India, he also lives outside India, and there is a body corporate, right? All these are partners of ABC LLP. So here these 2 are non-resident, they will not qualify. This one can become designated partner, right? He can become designated partner. This body corporate will make a nominee, and this nominee will be your designated partner. Okay, now this nominee can become your designated partner. Clear everyone? Designated partner is very important. They can ask you for around like 4 marks. They can ask you what all things are there. They can ask you a case study based on this, like nominee, when can they become the partner, designated partners. Then they can ask you resident of India. There is one example given in your context in your module, that they say that this person is leaving India, she gets married, a sister of Mr. something, Mr. X gets married and she leaves India. So that time she will not be the designated partner if she is a designated partner in the firm. Okay, clear? Great. Let's go ahead. Okay, 1 second. Yeah. Characteristics of LLP. Now, what are the characteristics of LLP? They can give you a short note kind of thing. They can ask you, describe the characteristics of LLP. So, we should be well versed that it is a body corporate. As per the Companies Act, they have said that LLP is also included in body corporate. Foreign LLP is also included in body corporate. Company incorporated outside India is also a body corporate. Perpetual succession. Even if the firm, all the partners retire, you can still continue the firm. Like even if one partner is there, perpetual succession concept will apply. Separate legal entities there of LLP. Mutual agency between the partners, there is mutual agreement. LLP agreement is to be formed. It is an artificial legal person created by law. LLP can have a common seal. LLP has limited liability. Management of business is done by one or all can do the business. Minimum and maximum number of partners you have to specify. Business for profit only. LLP is formed only for profit basis. Investigation can be done. Okay, these things you should remember. Business for profit only, this much is enough. Investigation and all this is not very much relevant. Okay. Now, I hope LLP is very clear to you people. Let's see what are the advantages of LLP. It is organized and operates on the basis of an agreement. You have an agreement. Written agreement is compulsory in LLP. So that is the basis for, that is an advantage for LLP. Even if some disputes happen, you can always take the shelter of agreement. Provides flexibility without imposing detailed legal and procedural requirements. You have less legal requirements, procedural requirements compared to the Companies Act. It is very easy to form. All partners enjoy limited liability. Flexible capital structure. You can decide the capital structure as you want, and it is easy to dissolve. Okay. I hope we are clear till here. Great. Now, incorporation of LLP. Yeah, so we have next one, that is your incorporation of LLP. Incorporation document. Two or more persons associated for carrying on a lawful business with a view to profit shall subscribe their names to an incorporation document. Two or more partners who want to do a business that is going to do profit and that is a lawful business, right? It is important they do a lawful business. Will subscribe, will write their names in the LLP agreement incorporation. Incorporation document shall be filled in such a manner and with such fees as may be prescribed by registrar of the state in which the registered office of LLP is to be situated. If I am forming an LLP in Mumbai, so registrar office of firms in Mumbai, I have to do in that manner. Whatever form they will say, I will have to fill with fees that they prescribe. Okay. With your incorporation document, some statements are to be filed. What are these? There shall be filed along with incorporation document a statement in the prescribed form. They will give a statement that these are the partners who are going to function, etc. All these things are to be written in that statement. Made by either an advocate or a company secretary or chartered accountant or a cost accountant who is engaged in formation of LLP. This statement is to be made either by an advocate, company secretary, chartered accountant or a cost accountant who is engaged in formation of LLP. He is going to form the LLP for you. By anyone who subscribed his name to the incorporation documents. Okay, and anyone who has subscribed his name, they can also form this statement with the help of chartered accountant, company secretary, advocate or cost accountant. That all the requirements of this act and the rules made thereunder have been complied. You have to say that all the requirements we are complying, all the rules we are complying in respect of incorporation and matters precedent and incidental thereto, and all the matters that are to be disclosed while incorporation, before incorporation and post incorporation, we are giving over here. We are writing over here. So you have to maintain the transparency. Next is the incorporation document shall be in a form as may be prescribed. Whatever form they will prescribe, that is the form you have to use. You have to state the name of LLP, proposed business of LLP, what business LLP is going to do. State the address of registered place of business where the business is going to be done. Name and address of each of person who are the partners of LLP in incorporation. Name and address of the partners of LLP. Also somewhere they ask for age also. So here it is not given, will be not taking that. State the name and address of the person who are to be designated partners. Here one additional requirement is there, that designated partner's address also, name also is to be given. Contain such other information concerning the proposed LLP as may be prescribed. Whatever other information you want to provide and the LLP Act tells you to give, you have to write in the incorporation document. Okay. If a person makes a statement as discussed above which he knows to be false or does not believe to be true, shall be punishable. If you are giving any false information in your incorporation document agreement, then you will be liable with imprisonment for a term which may extend to 2 years and a fine which shall not be less than 10,000 but which may extend to 5 lakhs. So here you have to remember 2 years imprisonment and fine lying between 10,000 to rupees 5 lakh. Okay, clear? Great. Let's go ahead. Let's see what's the next concept for us. Incorporation by registration. The registrar shall retain the incorporation document and shall within a period of 14 days register the incorporation documents. When you give the incorporation documents, within 14 days he will register your firm, register your LLP firm in the business, okay, along with other LLPs. Give a certificate that LLP is incorporated by the name specified therein. They will also give you a certificate which will show that this is the name of LLP. This LLP is formed from this date. Certificate issued shall be signed by the registrar and authenticated by official seal. So on the certificate, sign of registrar will be there and official seal will be there. Certificate shall be conclusive evidence that LLP is incorporated by the name specified therein. If I form ABC LLP, so I should have the LLP formation certificate, incorporation certificate, so that tomorrow another company another firm cannot come and say that ABC is our name. Okay. When you are registering with the registrar, he will make sure that the name is unique and you are given the exact name. Okay, so LLP incorporation document is very much important. They can straight away ask you a direct question. Okay, then we have registered office of LLP and changes there. Now, registered office, all communication and notices will be given to the registered office. Where your registered office there, you will get all the notice, communication, intimations over there. Manner of sending, they can send it by post under a certificate of posting or by registered post, they can send it. They will send it to you by a post or by a registered post like the government post, they can do it. Now, if you are changing registered office, change in the place of its registered office and file the notice of such change with the registrar. First you want to change, so you need to file the change with registrar. File the change with registrar. Okay, second. Now, first step that you do is file the change with registrar, right? Then in such a form and manner as they will prescribe, they will say how you have to give it, subject to conditions as may be prescribed. If they give some conditions, you have to do it along with the prescribed fees, right? They will give you prescribed fees that you will have to pay. Any such change shall take effect only upon filing. When you file this change with the registrar, then only your registered office place will be changed. Okay, and default LLP and its every partner, like if you change the business and you do not inform the registrar, so then what is the penalty? Penalty of rupees 500 for each day during which the default continues. Whenever you default, 500 rupees per day you have to pay, subject to a maximum of 50,000. So 50,000 is the maximum penalty they will be levying from. Okay, so whenever a change is there in LLP, you have to inform. If you do not inform, the partners do not inform, then the penalty is rupees 500 for each day and for the continuing default, subject to maximum of 50,000. Okay, incorporation, you give false details, 2 years of imprisonment, maximum 2 years of imprisonment they can give you, or they can give you a fine which can be from 10,000 to 5 lakh. Okay, effect of registration. Now, On registration, LLP shall by its name capable of, if you have got registered, your name is capable of suing or being sued. You can sue other people can sue you. Having a common seal if it is decided to have one. If you decide that ABC LLP should have a common seal, this should be a seal kind of thing. So that seal also you can have. Doing and suffering such other acts and things as body corporate may lawfully do and suffer. So all the body corporate things that are applicable will be applicable on LLP also. Then also along with this, acquiring, owning, holding and developing or disposing of property, whether movable or immovable, intangible or tangible, can be taken. So your LLP can buy a property, they can own a property, hold a property, develop a property, or they can construct a property, sell off a property. It can be a movable property, immovable property, tangible property, or a intangible. Okay. So all these powers you get after registration. This is the effect of registration. Okay. Let's talk about the name. Every limited liability partnership shall have either the words at the last words of its name, limited liability partnership, or the acronym LLP. So I wrote ABC LLP. So this is the name. This should be included LLP. You write the entire thing or you can use the acronym. No LLP shall be registered by a name which in the opinion of central government is undesirable. If you write some fancy name but that is not appropriate as per central government, you can't take that name. Identical or too nearly resembles that of any other LLP. You are writing ABC LLP, other one is says I want to write ABCD LLP. So here also this is similar. In fact, in actual life there is no ABC or ABCD LLP. You can say like real M, okay, LLP. So the other one, what they will do? Real ME LLP, right? So now these words are very similar. When you pronounce, it's real, right? So here, these type of things are not allowed. Identical or too nearly resembles to any other name. That is also not allowed. Okay, they have their different trademarks also. Then we have next one is reservation of name. So reservation of name is something that you can do for a proposed LLP. You can go to LLP registrar earlier and tell them we want to reserve this name. Okay, name to which LLP proposes to change its name. If you want to change a name, that also you can go and reserve that this is a trending name. Now I want this name of my LLP. So you can get it done. Okay. Registrar may, if he satisfied, subject to rules prescribed that the name be reserved is not one which may be rejected on any ground. He will make sure that the name that he is reserving for you cannot be rejected on any ground. And the reservation of the name can be done for a period of 3 months. Okay. You have to give the intimation to registrar and in 3 months only you have to finalize it. Okay. Maximum you can reserve the name for 3 months. Then we have partners and their relation. On the incorporation of LLP, partners shall be the person who subscribed their name to incorporation of documents. So partners are the people who have subscribed, who have written their names in the incorporation document. And any other person by and in accordance with LLP agreement. The name of the people who is written in LLP agreement will be the partners. Okay. Cessation of partnership interest. A partner may cease to be a partner of LLP in accordance with the agreement with the other partners. If you don't want to continue partner of LLP, you have to inform the other partners. Or in absence of agreement with other partners, you have to give a notice in writing for not less than 30 days to the partners. And you have to tell them, now I want to resign from this partnership. So then you can resign. Either in the agreement it is written that you are going to work only for few years. That is there. If you have not written that you are going to work only for few years, you can resign by giving a notice. Okay, great. Now what we have next is how LLP is different from others. That is important. Cessation of partnership is not very much given in your book. Change of name of LLP was given, and then how it is distinguishing from other types of LLPs, that is there. Okay. Now I hope you know the charts of this LLP, like how it is different from other particular things, like other chapters, other type of formations like limited liability partnership and limited liability company, how it is different. I hope you all are aware about it, right? If you want, you can just read that differences once or twice, because they can directly in your examination ask you the difference between LLP and partnership, LLP and company, right? These type of differences they can ask you. In your module they have given LLP and partnership, LLP and company, right? So you have to go through that differences. It is very easy, and you can do it very nicely, you can revise it very nicely, so that if a direct question comes in our examination, we be able to answer it properly. Okay, clear? So that was it about LLP. I hope you liked the lecture and it was very much helpful for you. I have revised all the concepts in a speed. I hope you will be matching up with that because we have a time constraint. Okay, so I'll see you in the next marathon lecture video, next part, next chapter soon. Bye.